Utah does not require their brokers to be bonded. The reason why is because in Utah, we have the Real Estate Recovery Fund. The Real Estate Recovery Fund is a pool of money that when you apply for a license and when you renew your license, little bits of money are taken out of that license fee and put into the recovery fund. By law, the recovery fund must have, at the beginning of any fiscal year, a minimum of $100,000. The purpose of this fund is to reimburse the public for harm caused by dishonest licensees, and also to provide revenue for research and education in the real estate field. If a consumer is successful in tapping the fund, the maximum amount that they can get out of the fund is $10,000. And the maximum amount the fund will pay out for any one licensee is $50,000. Okay, let's go through the numbers one more time. $100,000 is the minimum amount that must be in the fund at the beginning of each fiscal year. $10,000 is the max that any consumer can tap the fund for their aggrieved problem that they had with the agent. That, of course, only comes out by judgment and court order. And the maximum that can be paid out for any one agent is $50,000. By the way, right now on renewal fees, $36 goes into the fund from brokers and $24 goes into the fund for agents. And that changes from time to time, but that's what it is right now. Brokers are responsible for record keeping. But agents have a responsibility in that regard as well, and it's wise if you keep your own records. The division can require records from agents. If your broker's gone out of business or moved out of the state, it might be difficult to obtain those records, so you should have your own copy of all the transactions you've ever been involved with. The records must be kept for 3 full calendar years following the year of the transaction. So, if you had a closing that occurred in, let's say, December of any one year, those records only have to be kept about 37 months, the rest of November and then 3 full calendar years. But if you have closings in the first of the year, January, February, those records are kept almost 4 full years. But it's 3 full calendar years following the year of the transaction that records must be kept. And the division can require those records from an agent or from a broker. It's primarily a broker responsibility, but please keep your own records. It's something you need to do. In regards to Utah law, there is a term called statement of account. If you have a transaction under contract, it's pending, it's an escrow, and a consumer feels that you're not keeping them apprised of what's happening with their particular transaction, they can formally request what's called a statement of account. Statement of account is a requirement that the broker now has to give a written report on what's happening with that transaction every 30 days until that contract either closes or fails. And that's called a statement of account. It's not how much money you owe Discover Card. Its statement of account is when a consumer requests a report. Now, hopefully you're keeping in touch with your buyers and sellers on a regular basis anyway, because that's the proper way to do business.